Hello, my name is Stephen Stein, and I'm an attorney with Greenberg Glusker, and along with the partner organizations reflected on this side, this is our third module for the Small Claims Clinic presentation, and this concerns how to serve defendants. So let's go through that process. So serving service, just taking a step back, is the way that you sort of properly notify the defendant of your lawsuit in a way that complies with the rules governing the small claims process. So the first thing you're going to want to do, if it's not something that you already have, is figuring out the defendant's address. So you got to try to locate the defendant. And here are some tips on how to do so depending on the type of the defendant. So if the defendant is, for example, a registered entity, then one way to find that the defendant's address, the address that the defendant has given California government and has said, hey, this is the address I'm supposed to be served at, is to go to the website for the California Secretary of State. We have the URL right there, and enter the name of the entity, and then the entity's address will show, and that's where you would serve the entity. If, to give some other examples, the defendant is an individual and you have some information relating to the defendant, such as the defendant's telephone number, the public library actually has a reverse telephone directory so that can help you locate the defendant. Other places to find addresses for potential defendants include, tax information that can be available online. And honestly, Google can be a good way to try to define a defendant's address. So there are many tools at your disposal if you're having issues locating a defendant. So let's say you've located the defendant. You have found the address at which it is appropriate to serve the defendant. What's next? So the next step is actually serving the defendant at that address. And so, again, this is the correct way of notifying the defendant about the lawsuit and requiring his or her appearance, and it's called service of process. And this means that someone other than yourself, so it could be a friend, relative, or registered process server, who is 18 years or older and not a party to the lawsuit, gives a copy of plaintiff's claim form, the SC-100 form, to each defendant. And there are three different ways you could do that: personal service, substituted personal service, and certified mail. And we're going to get into those three ways shortly. So you give a copy of plaintiff's claim form to each defendant, and by you, I mean a third party does that. And then the defendant, and then the person who has given a copy of the plaintiff's claim form to each defendant signs a form called the proof of service form, the SC-104 form, for each defendant, which is then filed with the small claims clerk at least 5 days before the hearing. And this is the form that sort of shows the clerk, hey, this lawsuit has been properly served. And we're going to get into this, but there's a trick, if you will, for service, and that can be that the sheriff's office is willing to serve defendants by personal service. So that's just something to keep in mind and something we'll discuss shortly. So we talked about the different methods of service. Here's the first and the best. So personal service means sort of what you think it would mean. It means hand delivering the plaintiff's claim form to the defendant or to the defendant's agents. And as we mentioned, one of the best ways to do this is to have the sheriff serve the defendant. That's an additional $50 fee, but it can be waived if you're low income. To have the sheriff serve the defendant, you must locate the correct sheriff's office. For Los Angeles County, you can use the website lasd.org in order to find the correct sheriff's office. But there are also sheriff's offices at many courthouses. So if you reach out to a courthouse or go to the courthouse, you should be able to find the sheriff's office there. And then at least 4 weeks before the hearing date, you deliver 2 copies of the plaintiff's claim SC-100 form to the branch office, and you provide the sheriff with sheriff's instructions, i.e. an address for service where a defendant works or lives. And then you pay the $50 fee unless you get a fee waiver. And then the sheriff will mail a certificate of service to the court and a notice of service to the plaintiff if the plaintiff's claim form is served. If not served, a not found, no service return is mailed to the plaintiff, explaining the reason for non-service. So let's talk about, setting aside sort of the sheriff helping out on things, how you serve different types of defendants. So if it's an individual, you need to serve that defendant in person or someone authorized to receive service. If it's a business, you need to serve sort of the agent for that business. And again, if it's a registered business, if it's a registered LLC, corporation, it's going to have someone designated as an agent with the California Secretary of State that you can figure out, and you can figure out who that agent is via the California Secretary of State's website. So, that's just a handy tool to have available. Let's say, for example, that you're suing a landlord. Generally, you can serve the property owner or even the manager for the property. So those are just some ideas to keep in mind with respect to different types of individuals and business who you're personally serving. But sort of the big takeaway is personal service is the best way to serve a small claims action, because you sort of know if you personally serve the action, you've done it right. The next best way is substituted personal service. And that means personal service on someone other than the defendant, and then sending a copy of the plaintiff's claim form by mail to that same address. So if the sheriff or other third party who's going to serve the defendant goes to the defendant's house or business and defendant isn't there, the defendant may be served by leaving a copy with someone else and then mailing the copy to that address. This is called substituted personal service. That is personal service on someone other than the defendant. So let's give some examples. If the defendant is an individual, you would first leave a copy of the plaintiff's claim form at defendant's house or business with a person 18 years or older, a member of household, or someone apparently in charge, and inform them of what the papers are for. And then you'd mail the second copy by first-class postage prepaid to the same place where the process was left. If it's a corporation or business, you would, and when I say you, I'm referring to the third party who is serving the papers. That third party would go to the office of the business during usual office hours and leave the papers with an individual who appears to be in charge of things. And then again, a second copy would be mailed by first-class postage prepaid to that same place. Now, note with respect to personal service and substituted personal service must be made 15 days before the hearing, 20 days if you're dealing with the out-of-county defendant, and substituted service must be made 25 days before the hearing if it's an in-county defendant, or 30 days if it's an out-of-county defendant, when service is considered complete on the 10th day after mailing. Now, the third and sort of least favored method for service is service by certified mail. We would generally recommend against doing this, but if you are doing it, here's what that entails. So it must be done at the clerk's office, at the courthouse. The cost is $15, and service is deemed complete once the clerk receives a return receipt signed by the person identified to receive service. Once the plaintiff's claim form leaves the clerk's office, it's no longer the clerk's responsibility. Any delivery and tracing questions must be made to the post office. So you want to be proactive and call the clerk 10 to 15 days before the court date to determine if service is completed. This means that defendant signed and mailed back the return receipt, and you should have a case number and hearing date ready if you're calling. As we flagged, there are problems with this. There's a low success rate, about 50%, because of avoidance by defendant and invalid service. And what that means is, maybe the defendant has an illegible signature or something like that. And so the court clerk determines that the requirements relating to certified service by certified mail haven't been met. Now, what if you can't serve the defendant on time? If you haven't completed service on the defendant before the hearing, you may either dismiss the claim without prejudice and refile with proper service, but then you sort of have to start that process all over. It could create statute of limitations issues depending on when the harm you suffered occurred. So that's one option. Alternatively, at least 10 days before the hearing, you could file a request to postpone trial. That's the SC 150 form to postpone the hearing and serve the defendant. So those are your two options. Now, let's also look at this from the defendant's perspective. Just like we've been talking about all the sort of requirements you need to comply with to serve, from the defendant's perspective, what if those requirements haven't been complied with? So let's say you've been served, but was service proper? If you're personally were served, you should have received the plaintiff's claim form 15 days before the hearing if you're an in-county defendant. And, if you're served by any other method, if you're an in-county defendant, you must have received the plaintiff's claim form 25 days beforehand. And so, those are just things from the defendant's perspective you want to consider. And, if you don't believe you were properly served, but you received the claim form before the hearing, you need to be careful about this, because even if you don't show up, there's a risk that even though you weren't properly served, the court still goes ahead and hears the plaintiff's claim and decides the plaintiff's claim. And that might result in a judgment being entered against you. So the general rule of thumb is better safe than sorry. If you're aware of the hearing, it probably makes sense to go to it. And certainly when you're at the hearing, you could tell the court you were improperly served, but the court might not care because you're already at the hearing. So it gets a little tricky. Other things to consider from the defendant's perspective, is this the proper location? Is this the proper courthouse? And if it isn't, you can write a letter to the court, to the department that's going to hear the small claims action, explaining why this isn't the right courthouse and asking for the case to be dismissed or to be transferred to the correct courthouse. And you can also tell the court that at the hearing, but again, it's always possible if you show up, the judge might just decide to let the hearing go forward and decide the claim. So you need to be prepared if that's the route you choose. Again, another thing is to think about whether the claim belongs in small claims court, whether the plaintiff is claiming something other than money, whether the plaintiff is claiming damages in excess of the caps that we've discussed on small claims actions and so forth. So again, from the defendant's perspective, there might be certain technicalities that aren't being complied with on service, but if you're aware of the hearing, it probably makes sense to show up. So that concludes our presentation about service in Module 3, and the next module will involve the small claims hearing and what happens after that.